All right, hey everyone, it's January 12th, the year 2017, and this is the final video from Ed Brown's 20-page letter. Let's get started. Words and phrases of the United States. To fully comprehend this web link, it is an excellent idea to familiarize yourself with the word and phrase definitions on this sublink. For your convenience, the unfamiliar words and phrases referenced throughout this web link are defined herein and will also appear in blue when used within the write-ups themselves. If you have forgotten the meaning of the words or phrases, you only need to click on the word or phrase referenced in the write-up in blue, and the meaning will appear in a box for you to review. The definitions of the words and phrases below and throughout this link and its sublinks are mostly derived from Black's Law Dictionary. Black's is the highest authority that exists for the meaning of words and phrases relating to the exact lawful definitions used in law and courts across the United States. Please keep in mind as you read the lawful exact meaning of words and phrases, many of the definitions will be totally different than you were taught or have understood them to be. You will find out why as you review this link and its sublinks. The Black's definitions of words and phrases and other dictionaries used as references pertained only to the subject that is being discussed within this web link. Definition of words not used in lawmaking and by courts are condensed from Webster's and Random House and Oxford ACD and are so stated at the end of each definition, as are all references. Important note, when the names of people are defined or the names of courts, pay very close attention to the way each is spelled, as how they are spelled using all capital letters, partial capital letters, and no capital letters changes the meaning of people and courts by law. The law which changed the meaning of words is referenced at the end of each definition. Keep in mind as you read these legal definitions on this sublink and throughout all the sublinks of this link, keep in mind the people that devised this conspiratorial destruction of a republic and constitution were and currently are zealots. These zealots devised and revised sinister plans of deceit upon the trusting citizens of the United States to take total control of the United States from within and overthrow the government that was formed in 1791. Word and phrase definitions. All right. Cloak. Used by the unscrupulous of watchwords of Western democracy as onslaughts of a populace using liberty ASA for an attack upon order and stability. Reference Webster's Unabridged 1993. Using other words for the same definition and for this website, cloak means zealots acting as a democracy put forth enormous amounts of propaganda falsehoods via intentional misleading of words and phrases to the population of Republic citizens as an attack upon order and stability of the Republic of the United States. Deceit, practice of misrepresenting the truth, dishonest act or statement. Reference Random House, Webster's, and Oxford ACD. De facto court government. An accepted way of court or government is operated, however, its operation is unlawful or illegitimate. Reference Black 6-7. De facto judge, a judge which conducts a court under the pretense of law, however not under the law, a judge in which he or she's authority is defective, not real law. District of Columbia, a federal district of the United States, an extension of Washington, D.C., reference Oxford ACD. As a fact, the District of Columbia is 68 square miles and houses the seat of government, which by the Constitution is not to exceed 10 square miles. It is, in fact, a territory of the United States, not a state of the Union. The District of Columbia was unlawfully declared a state by act of Congress, the legislature, in 1934, Title IV, Section 112 AB, for the illegal and unconstitutional purpose of crime prevention, to form agencies and pass laws for the District of Columbia and illegally enforce such laws under the United States of America against the sovereign citizens within the now 51 states of the United States. In doing this, the legislature went directly against the U.S. Constitution, essentially abolishing it. Since 1934, these high officials and others have cloaked this one of many evil deeds, which has led to the false imprisonment and inhumane deaths of tens of thousands of sovereign citizens of the United States, and is in full force today. The United States Constitution forbids the forming of a state from two or more states or any parts of existing states. U.S. Constitution, Article 4, Section 3. Fanatical fanatic, an obsessed person with a single-minded interest. Federal criminal courts, non-constitutional. Constitutional note. There are many federal courts. However, the courts referenced within this website are federal criminal courts authorized under the U.S. Constitution and other criminal legislative courts authorized by acts of Congress and or for the District of Columbia. For the most part, over 99% of the time, these non-constitutional courts are knowingly unlawful and inhumane and in direct, deliberate violation of the Constitution when applied to either sovereign citizens or any of the sovereign states of the 50 states of the Union. Additional note. These courts are clearly identified within the U.S. Constitution and throughout the laws passed by the U.S. Congress over the past 100 years. Pay very close attention to the way each one of these federal criminal courts are spelled, using no capital letters, some capital letters, and all capital letters. There is no mistake or typo, as these same exact courts appear in their exact spellings with and without capital letters over the last 100 years consistently, hundreds of thousands of times in laws passed, cases cited, and the headings on federal court records, documents, and indictments. These evil, deceitful tactics were deliberate, and the reason is set forth on this web link and sublinks. A constitutional criminal courts formed. 1. The Supreme Court of the United States is in fact the highest court of the United States and was established under the U.S. Constitution, Article 3, Section 1. 2. The appellate courts of the United States are in fact appellate courts which must adhere to the laws put forth by the Constitution. 3. The district courts of the United States are in fact courts of original jurisdiction for crimes against the United States and must adhere to the laws put forth in the Constitution. 4. The district courts and appellate courts of the United States, which are constitutional courts under Article 3 of the Constitution, had a name substitution approval between the years of 1934 and 1948. These constitutional Article 3 courts may now be called either United States District Court or United States Court of Appeals or District or Appellate Courts of the United States. Refer to Rule 1, 1948 Amendment, Federal Rules of Criminal Procedure, Advisory Committee Notes. Note: on this name change, although the first letters in the United States are capitalized, which is proper, there is no capital letters whatsoever in either the term District Court or the Court of Appeals. This is by design and deliberate to fool the public into believing that the now added name of the constitutional Article 3 United States District Court is the exact same court as the United States District Court or the United States District Court, which it is not. Likewise, the constitutional appellate courts, now named United States Court of Appeals, is not the territorial appellate court called the United States Court of Appeals or the United States Court of Appeals. Important note: there are many courts with different names. 50 is a fair figure, and vast majority of courts are created by the U.S. legislature. The vast majority are unlawful when criminally applied to people within the United States. Before the name change, it was very easy to detect the federal courts formed and operating under the Constitution. This because they were always identified as courts of the United States, such as the District Court of the United States and appellate courts of the United States. The name change of these courts functioning under the Constitution was made for the express purpose to convince the people of the United States that were in federal court operating under the Constitution when in fact they were not. The appearance of a constitutional court but not a constitutional court. 5. The United States District Court and appellate courts are recognized courts of record within the United States and are non-constitutional courts when used to enforce laws against the people within the 50 states. B. Non-constitutional courts. 1. The United States District Court is a recognized legislative court formed by the District of Columbia by the legislature to have jurisdiction over the territories owned by the United States or possessed by the United States, as well as a court of record. These courts do not have jurisdiction over any person committing alleged crimes inside the boundaries of the 50 states of the Union. These district courts, spelled with the capital D and C, were created to appear as they appear under the U.S. Constitution, when for the most part they do not refer Law Title 28 to the United States Appellate Court, referenced above paragraph 3. The United States District Court, referenced above 2 paragraphs, with one important addition. This mystery federal court does not exist within any laws, nor is it referenced anywhere that 3 attorneys and 4 legal researchers could find in years of research. To legally exist, this court must be formed by the legislature or the Constitution. No one seems to have formed this court. This court is a kangaroo court of no authority, offering a jury trial unlawfully and poorly attempting to give the appearance of a constitutional court. 4. The United States Appellate Court, reference above paragraph. Important note: the federal judges are the same judges which control the constitutional courts and the non-constitutional federal courts, appearing to the public as operating under the Constitution. Refer to the U.S. Constitution and all laws. Federal trial by jury, jury trial, trial by jury is guaranteed by the U.S. Constitution. The two terms clearly appear to have different meanings, although deliberately hidden, cloaked from the public knowledge of U.S. citizens. Federal trial by jury, guaranteed by the Constitution for all citizens of the 50 states in the criminal federal cases, an impartial jury of the person's peers who are sovereign citizens of the Republic of the United States. As sovereign citizens, the jury, while in the courtroom, is the law of the land and may decide each case as to whether any law is applicable, while having the power to void any law on a case-by-case basis. As a group, each jury is the government and decides exactly what the law states as pertaining to the accused innocence or guilt. The presiding judge nor anyone else may instruct the jury as to what the law says or means. The jury is present at every stage of the trial and hears all arguments. There are no secret sidebars or preliminary court housekeeping without the jury being present. The judge is not the law in the courtroom, the jury is. The judge may not decide any law nor issue any jury instructions pertaining to the guilt or innocence of the accused. A judge is merely a referee between the accused, the government, and the jury. There are no rules of evidence, and the judge has no discretion to not admit any relevant evidence. The prosecution does not always have the right to present his final argument against the defendant just before the jury makes its decision. These are only a few of the differences between a trial by jury under the Constitution and non-constitutional jury trials. Federal jury trial. A jury trial is authorized under the law at Title 18, Section 3691, under contempts constituting crimes, and state as follows: shall conform as near as may be to the practice in other criminal cases. In other words, the appearance of law jury, not real law jury. It clearly appears that a federal jury trial is a jury brought forth in a federal courtroom to appear. Hold on. I lost my place. I lost it. To appear that the defendant is receiving a trial in a constitutional court, when in fact the defendant is not. In a jury trial, the federal judge has total discretion to throw out any evidence, disqualify any witnesses and testimony, hold secret sidebar discussions kept from the ears of the jurors, operate under local rules under the discretion of the District of Columbia, force defense attorneys to swear to operate under the court's made-up rules directed by the District of Columbia, dictate to the jury what the law says and means, order the jury to what to consider and, in essence, what to find, guilt or innocence, and allow the government to sway the jury by presenting their final argument last every time before the jury makes its decision. The person judge that controls the jury controls the verdict. Jury trial is the appearance of a trial by jury, not trial by jury. These are only a few of the differences between a federal non-constitutional jury trial and a constitutional trial by jury, the laws and titles as stated, and the millions of cases tried. Foreign state. The term is used to refer to another state, an American state different from the one under discussion. The several United States are considered foreign to each other. Idem sonans. The term means in law names that sound the same when spoken, however, are not spelled exactly the same in actuality. Additionally, the spelling of names in all capital letters, partial capital letters, and no capital letters have totally different meanings in most all cases in law, on legal documents, names, or courts, and upon court records. As an example, the United States District Court is not the same court as the United States District Court or the United States District Court. A name such as James T. Kimball is not the same person necessarily as James T. Kimball in legal terms, and unless James T. Kimball allows and legally accepts the name James T. Kimball, refer to Black 6-7. Kangaroo Court, a deceptive court in which the outcome is already known before the trial. Bias. A person's rights do not exist. Reference Blacks 6-7. Legal person / artificial person, an entity coded by law and given certain legal rights and duties of a human being, real or imaginary, who for legal purposes is treated as a human being. Liberty, freedom from all restraints except such as justly imposed by law. A franchise or personal power being some part of the sovereign power vested in an individual, guaranteed protection against interference with the interests and rights held clear and important by large classes of civilized men. Northwest Ordinance. The Northwest Ordinance was adopted into the U.S. Constitution as the law of the land for all states in the Union. Northwest Ordinance. Peers / jury of your peers, peers are other people of equal status and rank as to one another. Presumably, people of equal knowledge and stature in life. Jury of your peers, although not clearly defined in modern references, appears to be people standing in judgment of others, equal in status and knowledge. A jury of one's peers is an absolute right under the law of the land, the U.S. Constitution via the Northwest Ordinance, as is trial by jury. Republic / democracy, a system of government in which the people hold sovereign power and elects representatives who exercise that power, in contrast, on the one hand, with pure democracy, in which the people or community as an organized whole wield the sovereign power of government, and on the other, with the rule of one person. Sovereign, a person vested with the independent and supreme authority, also a body or state. Sovereign power, the power to make and enforce laws. Sovereign state, an independent existence not dependent upon any larger whole. A government in itself not subject to any larger whole, a political community whose members are subject to some control authority, who commands the members must obey, such as each state laws. Title, a law or laws passed by U.S. Congress, by act or otherwise. Treason, the crime of betraying one's country, attempting to kill the sovereign or overthrow the government. The action of betraying someone or something. United States. Is the United States referenced in the Constitution as union of the states with the seat of government presently located in the District of Columbia, which is not a union state. The United States government consists of elected officials from the currently 50 states, which may pass criminal laws for the United States territories and possessions outside the limits of the individual 50 states, however, may not pass or enforce any laws within any of the 50 states or against state citizens, unless such laws are passed as constitutional amendments and stated within the Constitution. Currently, only 3 crimes are mentioned within the Constitution. They are treason, counterfeiting, or piracy. Refer to the U.S. Constitution, Article 1, Section 8, Article 3, Section 2, Section 3. The United States, as referenced within the Constitution as the union of the several states, 50 states, and seat of government, is not the United States of America, which is referenced in a territorial sense, as the several states located on the continent of the North America. Thus, the United States of America, referenced in the introduction of the Constitution prior to Article 1, is used in a territorial sense. United States of America, 1, is not the United States in the sense of the constitutional laws or rights. 2, the United States of America is a corporate entity initiated to conduct the business of the United States, which filed for bankruptcy and reorganization in 1934 and has remained so to present date. The United States is the body sovereign and must function under the Constitution, while the United States of America is the body corporate and has no responsibility or allegiance to the U.S. Constitution whatsoever. Okay, let's keep going. United States of America. This item sonans does not appear in any law that could be found to legally exist by 3 attorneys and many legal researchers after years of research. The United States of America appears to be an unlawful entity of absolutely no authority who has been unlawfully indicting citizens of the 50 states for over 40 years, apparently for the District of Columbia. U.S. citizen is a natural person born in one of the states of the United States or domiciled with permission in a particular state, city, or town. Reference Blacks and Oxford ACD. U.S. Constitution. The United States Constitution is the supreme law of the land, as is the Northwest Ordinance, which was adopted in its entirety within the Constitution to be effective for all the states of the Union. U.S. Constitution. Also see Northwest Ordinance. Zealot. a fanatical person uncompromising in their pursuit of their political or other ideals. Additionally, for this website, the meaning is increased to mean a person or group of persons that are extremely wealthy and or are in positions of power, whose ambitions are to control large numbers of people, to include communities, states, and countries, to the detriment of the people, to increase their power and wealth. These fanatical people have no respect for humanity or human life. In their lust for power and money, pure evil. Okay, there's appears to be some sort of case or statute. I'm not going to read it. I'm just going to show it. So you can pause the video and read it if you want to. I'll slowly go through it. Let me just read the main sections. Appears to be Hooven and Allison Company petitioner Williams S. Evett versus William S. Evett, Tax Commissioner of Ohio. Commerce 48 import duties, exclusiveness of federal power delay. Commerce 209 state taxation imported goods. Commerce 206 exemption of imports from state taxation, purchaser as importer. Appeal Section 745, review of facts in order to determine whether federal right has been denied. Commerce Section 206, tax immunity of imports. Time of passing title as bearing on question whether purchaser was importer. I'm not even going to read the rest of this. You can read it. It's just too much. I think the reason this was shown is because it says the term United States right there. And it talks about has several senses. All right. Okay, that is Ed Brown's letter. I'm not censoring the man. You can take his writings and do with the information that he has provided, and do with that information as you desire.